Hey, welcome back. Well, we are joined here by Lee Mackey, partner and president at Mach Financial. Thank you so much for joining us.
Thanks for having me.
We sure appreciate it. Okay, today we're talking about estate planning, wills and things. It can be a bit confusing for some people, maybe who haven't got to the point in their life where they're thinking about it. Should we start thinking about estate planning and wills when? Like soon, now?
Yeah, thank you for having me. The thing that we tell the people that we work with is it's best to think about estate planning before you need it. Okay, do it long before you think you're going to need it. The worst time to do it is in a time of a crisis. Oftentimes we see couples, families, they'll put one in place before they go on vacation, leaving their children behind. That's oftentimes when we see that. But, you mentioned at the very beginning, wills and things. Most people, question what exactly is an estate plan. Of course, wills are the most common, but they involve anything that has to do with financial decisions, healthcare decisions. And so the basic estate plan typically consists of a will, possibly a trust, a revocable living trust, medical or healthcare powers of attorney, financial powers of attorney. So all of those tend to go into what many people consider to be their estate plan.
Well, you had said within that a will and the trust, the difference between the two?
Okay. A will is most common, and think of a will as, who you want to get what, okay? Wills are subject to probate. In this country, in Arkansas, if you leave a will, those assets, when you pass away, are subject to probate. It's a court process that goes through the dispensing or the distribution of your assets. It can be costly. It can take a fair amount of time, and it's public. Anything that goes through probate is open to viewing to anybody that wants to do that. So when you put assets in a revocable living trust, one big advantage to that is it's private. And it avoids probate, therefore saving potentially thousands of dollars and months of time.
I see.
And so once you get those in order, where do you put them? Who do you leave them with? How do you keep your will and your estate safe?
Great question. Oftentimes the attorney, if you work with an attorney, they'll keep it on file. We always recommend that our clients keep them in a safe place, a fireproof safe at home, a safety deposit box at your bank. We oftentimes will upload it to their files at the office. So having 2 or 3 different places, and then of course, if you've named an executor or a trustee, you oftentimes will let them know where they can find that in case you do pass away, something happens to you. They're readily available to those that you've named in your documents.
Well, can this become quite costly for someone to plan out their estate? Does it have to go through a lawyer, or just it's suggested that you need
to? Great questions. It can be costly. I mean, into the tune of thousands of dollars. You may ask, well, what is, somebody at Mach 1, and we're an investment and planning firm talking about estate planning. We feel that financial matters can't be handled in a vacuum. They need to be incorporated with all sorts of planning, including estate planning. One of the things that we're able to do with folks that work with us is through a company or entity called wealth.com. We're able to, for a planning fee, provide these services to our clients. But to your point, it can be very expensive. I mean, here in Northwest Arkansas, to get a good estate plan done with attorneys here that specialize in it, you're probably looking at $3,000, $4,000, $5,000 and up from there.
Definitely.
That is a little pricey. And I want to go back to, you were saying maybe you have an executor or someone like that when it comes to the will, the trust. What kind of people do y'all suggest for that? A family member, a friend from the outside? What's the most common, and what have you seen cause the least problems?
For an executor, that person is responsible for basically overseeing the will. That oftentimes is a surviving spouse. It can be another family member. It can be, a responsible adult child, a family friend. With regard to trustees for a trust, it can also be a family member. And oftentimes there you'll name a corporate trustee. Many banks will have trust departments. There are trust companies where there's family situations where there may be a special needs child. There may be a child or a family member that has a alcohol or drug problem where you want to protect that child. Oftentimes it's better to use a corporate trustee to help with that rather than another family member or a family friend.
So when it comes to estate planning, should we sort of factor that into our financial planning? I mean, is that part of it? It's not really necessarily a separate entity. It should be part of the process.
They should go together. I mean, they are separate. You know, financial matters involve your checking accounts and your savings and your investments. But estate planning can too, especially when there's beneficiary designations involved. Too often times people will work on their estate planning. They'll put wills and trust in place, but then they won't take care of the beneficiary designations that often exist with life insurance policies, annuities, 401k, IRAs, and oftentimes they're inconsistent. And so we advise all of our clients that when they're going through the process of estate planning, making sure that the beneficiary designations on their investments are consistent with their estate plan.
Well, Mackey, we are joined here by Lee Mackey, partner and president at Mach Financial. Thank you so much for being here this morning.
You bet. Glad to be here.
All right, so we are talking, if you missed the last half hour, we're talking about estate planning, everything centered around that. And for those maybe who didn't watch that, what exactly is estate planning?
Estate planning is, planning for your estate. It includes wills, trust, powers of attorney for health care, for financial reasons. One thing I didn't mention earlier, it also includes advanced directives, which are the living wills as well.
Absolutely. The living wills. Talk a little bit. What is that?
A living will is essentially, that those decisions that you make at the time of death. Do you want to be kept alive by artificial means? Do you want fluids? Do you want hydration? Do you want to be kept alive past the time when oftentimes the doctors have determined that, it was time to go?
Gotcha.
And there's a lot of thought and planning that goes into estate planning. So where do people start? What do they need? What are the things they need to think about?
That's a good question. You need to start now. Okay. There's really not an age, based. Oftentimes a misconception is, well, I need to have X amount of dollars, or I need to be close to retirement. Well, in fact, if you own assets, if you've got retirement accounts, if you've got children, then you need to do estate planning and start with the basics. Put a will in place. If you've got assets, you might want to look at a revocable living trust, which would allow you to avoid probate. If you've got children, it's imperative that you put together a plan, because then you're determining, you're making the decision of who's going to care for your minor children, not the court.
Absolutely. And can we ask, that question of everybody always says, if you write a will on a napkin or a piece of paper, is that a binding document or something like that?
Depends on what state you live in.
Okay.
Most of our viewers are in Arkansas, and Arkansas does allow holographic wills. That's what a handwritten note essentially is called, a holographic will. Arkansas allows it with certain conditions. Those are, you have to prove that that there was testamentary intent, that the person that was writing it intended it for it to be their will. You have to be able to prove that it's their handwriting. And so, yes, they are allowable. I've heard it compared this way. If you're building a house with just a hammer and no blueprint, you may get into the house, but you may not like what you have once you're in there. It may be a legal and valid will, but you're going to create probably more problems down the road. I mean, you're going to go to court to try to prove that it was in fact a will. I mean, if somebody was left out, they have a good chance to contest it and to fight it and to say, well, Uncle Joe or mom or dad didn't really mean that, because they were just scribbling it on a piece of paper.
Right.
So it can oftentimes create more problems than being helpful.
Gotcha.
Yeah, so the best is to not do it last minute on a napkin. Plan ahead.
Do it well before you think you need it. Absolutely.
And when it comes to people having those documents done, signed, what do we do from there? Who needs to keep those? Where do we put them?
Keep them in a safe place. If you have a fireproof container at the house, a fireproof safe, keep it at your bank, safety deposit box. Oftentimes the attorneys will keep copies. Us at Mach 1, we keep them in our client files electronically, because we're dealing with all sorts of planning with regard to our clients. And so we keep it. We want to know, oftentimes we are involved with a lot of that estate planning. And so it just makes sense for the professionals in your life to have that. Maybe not your children, but if they're named as executor or trustee, oftentimes you may even include them in having a copy.
Gotcha. And let's talk about what are some misconceptions about estate planning and wills.
And I mentioned that before, and oftentimes it is, well, I'm not old enough to have a will or a trust, or I don't have enough money. But as I said before, I mean, if you own property in the state of Arkansas, if you own a house, I mean, if you've got a retirement account, if you have children, you need to start. If you're over 18, you have to be over 18 to sign a contract in the state of Arkansas. So most people are, but start early. And the nice thing about it is, as life changes, so can your documents. What we're putting in place is not set in stone and forever forgotten. I recommend to everybody that we work with, every 18 months or so, pull it out, make sure things are the way that they still should be. If you've had a life event, if you've had a marriage, a divorce, a death, a move to a new state, you should review those documents and see if they're still effective and still make sense.
Well, I really liked what you said earlier, the difference between a will and a trust. A will basically has to go through probate, through the court system. It's public. A trust is more private and sort of it is what it is. But why then would anybody choose a will over a trust? Is it the cost to put it in place?
Oftentimes it is. Oftentimes it is that if you don't own a lot of assets, sometimes a will can be okay. Arkansas has a small estate exemption to where if you have assets less than $100,000, you can, at the death, the executor can essentially fill out a form, give it to the judge and say, this person died with less than $100,000. The judge will sign off as a small estate and you can avoid probate. So there are reasons like cost that come into that. But, if you've got assets at all, if you've got a family, trust oftentimes make the most sense. A revocable living trust.
Gotcha. Thank you so much. We appreciate you being here with us today. Thank you for
Hope it's been helpful.
asking. Yes, absolutely.